Hello, hello, Arkansas Jural Assembly. I am so excited to be here with you today, and wow, what a week we have had. It has been eventful, to say the least. You guys are just doing fantastic, and so tonight, as we've had our court case, now tonight what we're going to roll into is how to decipher the court of record. Let me minimize this. So how do we decipher the court of record? I want you guys to I want everyone that's here to just take a minute, and I want you to think of all the, cop shows that you've watched with all the juries and all the different things that you see in court session, everything we've learned, all of our lives, everything. And I want you to just ball it all up in your mind, ball it all up into your mind, and then just throw it in the trash. Because what we absolutely have to do is we must retrain our minds. Common law juries, common law courts, how everything works and how the whole world works according to common law is flipped upside on its head from what de facto and from what we've been taught. So forget all about that. What we need to learn and realize is that, yes, we are sovereigns. But just like Yeshua had 12 disciples, and the kings have their own courts. We are sovereigns. We're kings and queens, and we carry our courts with us. So our Arkansas Common Law Court, this group of jurors and court officials that are in this room with me or in this here with us, we're all sovereigns, but we all carry our court with us. We all are each other's jurors, we're each other's judges, we're each other's officials. This is how sovereigns operate. This is how they move. Kings did it. Yeshua did it. If you go back and look through history, you can go back and look all through history and all the major countries. Your kings had courts. The sovereigns had courts. And so that's what we need to retrain our mind. Now, the court of record in a common law court is a direct communication tool from the sovereign, who is the claimant, to the sovereign jury. It's a communication tool. When you come into our courts are built for the sovereign. The sovereign, in our side, the claimant is always going to be a sovereign, always. And our jury is always going to be sovereign. And so when the claimant writes out a court of record and gives it to the jury, there is going to be very key things that claimant is going to communicate to the jury, asking for things, telling you things, giving information for future reference. There's things in there. So tonight, my goal is not just to teach you the framework of the court of record and a verdict, but I want to teach you, the jury, how to frame the verdict from the court of record yourselves. Because if I can teach you guys how to frame this thing by yourselves, then it will be easier for you guys to come up with a verdict and to know that you're not missing anything that's important. Okay, so another thing on verdicts. We're used to the verdicts that are read in the court, that are read on TV that say, we find the defendant guilty, guilty of all charges, blah, 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 and that's all that's really read. In common law, the jury actually, their verdict is going to be actually quite longer, and it will be in a writing type form, kind of like the court of record, and there'll be different points that they'll hit. And so all of that will be done in like a type of writing. So let me show you, I'm going to give you guys what are some of the things when you first meet in the jury room, what are some of the things you need to do, and then how do you construct your verdict so that your verdict is complete and you don't miss anything. So the first question you have to ask yourself is, who's the injured party, or who's the injured parties out of the court of record? That's the first question you have to ask. Corpus delicti. Who is harmed or hurt or injured? So when you go through all of the whole case, you have to list out who all's injured. You could have more than one person injured. You could have a few people injured. But you have to figure out who are the injured parties that are mentioned here. How have they been injured? By who? Who were they injured by? When? When were they injured? When you do this, so you take your court of record, you look for the injured parties, you've heard testimony, and you write out, okay, these were who were injured. Then you make a list of each defendant, and this will help you to determine damages. When you're determining damages, you'll use the court of record, and then you'll also use the timeline of events to separate out the wrongful actions of the defendants and the injury caused. So, for example, and I forgot to write an example in here, but one of the examples is one of, let's just say an FTA warrant was issued, and it was issued by Petro, and it was for $5,000, and the declaimant bonded out. So when you go look at that on the timeline of events, it tells you who charged the arrest, who also for how much, and you would list the injury. So it would be like the injury is false arrest, and the injury also is bond money, out $5,000. So that's just an example, and you would name it with, say, this is Petro over here, and this is what she did, and then you have Mahoney over here, and this is what he did. Oh, he sold the horses. Okay, how much did he sell them for? We don't know, but can we get them? Different questions. So you would put, that's what that one did. So you will use the court of record and the timeline of events to separate out wrongful actions. So how is restitution brought? Well, first, I don't know, maybe I need to go to the timeline of events and show you guys. I don't know if you guys have actually looked into the timeline of events. Let me see. Timeline of events, where is it at? Here it is. Is it not open? So, for instance, on the timeline of events, so if you take the court of record, it has the law of the case, it has the timeline of events. This is a really condensed, your case numbers up at the top. This is a condensed version, so it'll show you what happened on each date. And it'll tell you where the exhibits are and where you can find them on which packet of exhibits. And for instance, for this case right here, 5727, all evidence of the court of record is found in packet 1 of the evidence file. So you would go look up packet 1, and they're labeled here, Exhibit G. It's on page of that packet 1, page 29 through 36, and that's the lease agreement. But let me get to one of the arrests. I don't see one of the arrests. Oh, it's because it switched over to this one. Hang on. Here it is. All right, so here is arrest warrant. This one was Hernsberger, but Hernsberger has retired, and so, but that amount was $5,000, and it tells you what page, and so there's that there. There's a copy of the bond. But all of these will tell you usually where your judges have things. So you can make a list with that. Now let me go back here to, all right, so the next question, once you figured out who was injured by who and when, Then you ask, how is restitution brought? So you gather up totals from the previous, list that you made and begin the process of figuring out between the jury, okay, this is what they've done, but you also got to take into consideration punitive damages, like was there job loss, fines, fees, attorneys, had they been detained? How long were they detained? Detainment also means having to hide and not be able to go home because you're still in a point of being detained. So, has it been 6 months, a year? How long have you been detained? Different things come into play. And so this is where the communication between the sovereign claimant and the jury is critical. And you're going to find that information in the court of record, and I'm going to show you how to find it. I'm going to keep reading through this. The next question that you've got is going to ask is, how do you reach a judgment and a verdict? So you go back through the court of record, and you read through the actions, the statement of actions, and the conclusion. Those subsections inside the court of record are going to give you most of the stuff that you're going to need as far as judgment is concerned, because it's going to be the conclusion from the claimant of, hey, this is everything that's happened to me, and here's the conclusion. It's going to be in that section, and it's going to be in the statement of actions. The statement of actions is up at the very front of the court of record, and it's going to list all the charges. It's going to tell you what those charges are, what they mean, and so you'll need to look through that. So you're going to look for how the charges are written. So when you go to the charges, how they're written, and if there's any remedy written into the charge. That's the interesting thing. With common law, when you have the definitions and things of different charges, a lot of times people write the remedy right into the charge or into the case or into, for instance, in Ex parte Milligan, they wrote the remedy of where we send our verdicts to, which is the state chief justice. It was written into Ex parte Milligan. And so here's an example here, and I'm going to show it to you here. On count 4, I'm actually going to just kind of start it with this one because this is a big one. In our charges, it's actually written in the definition what happens on here, and it's on count 4. It was from the grand jury. It was from the indictment, the original indictment from the grand jury, what they decided. They brought that forward. It's now inserted into the court of record, quoted, and we see that the state, what we're going to see is the state is held accountable when malicious prosecution is involved. So this means that our jury needs to start looking at how do we hold the state accountable. But I'm going to go there real quick because we're going to kind of start with that, and then I'll show you. I'll kind of show you some of the things we see from here. Let me go there. What page is that on? Just so I know. It's page 8. Okay, page 8 on the court of record. All right, so on the court of record, page 8, as I scroll to page 8, I'm going to show you guys the things that I've highlighted. So this is how y'all, this is our first time doing this. So in order for me to do this, I had to actually go through it myself. So what I did is I took the court of record and I just started highlighting things in different colors so that I could kind of put this thing together and be able to break it down into pieces that can be easily digested. So the first page is here. We're going to the second page. That's your law of your case, then your timeline of events. The commencement, that's basically saying that's Cheryl coming into court and who she is and who she's suing. It's got jurisdiction to tell us what jurisdiction we're in. It's got the Arkansas Constitution listed. And then the introduction. The introduction tells where jurisdiction was challenged. Okay, so this starts with her court cases with the challenge of jurisdiction in the introduction, and it goes through that. It mentions Ex parte Milligan. It mentions everything that happened during that. Now, when you come to number 9, the claimant is when you see claimant asks or claimant seeks or claimant wishes or claimant desires, or when you see anything like that, that is a direct communication from the claimant to the jury. So as a jury member, you need to look for that. That's what you're looking for. Where are they talking to me? Because they're going to be talking to you in here. So the claimant asks, who is the injured party? Who has the claimant harmed, brought injury to, or stolen from? Corpus delicti. Claimant is the only injured party in the above stated cases. So claimant right there is reaching out to you and saying, hey guys, look, I'm telling you right now, it's me that's the injured party here, not these other guys. So she's telling you to go look for the injured party. So that's what she said there. So it's highlighted. So then now you have your statement for cause. Okay, this is where you're going to have the actions. An action is like a charge. So when you hear me say action in the de facto court, they're going to say these are the charges that we've brought against you. So we say action. So here's the statement of cause for the action. This is going to be trespass on the case, malfeasance, dereliction of duty, theft, unlawful conversion, crime of personage, tort of malicious prosecution. Okay, so the trespass and the trespass on the case are actually what Cheryl is saying that they did because they've trampled the case over and over and they didn't answer jurisdiction. Those are for that. They're on trespass and trespass on the case. But the malfeasance, dereliction of duty, theft and unlawful conversion, crime of personage, and malicious prosecution, that actually was brought forth by the grand jury. So as we read through this and look, this is Cheryl. She's telling you, hey, man, I brought these actions because here's where my rights were violated, and here's in the Constitution and the Bill of Rights where they were violated. So she's telling you that. And so once she gets done telling you that, all of a sudden she tells you that the claimant is and was protected by those rights at all times. But here she's seeking. So right there, boom, claimant seeks. My radar automatically goes up. If the claimant is seeking something, that means she's talking to the jury again. So now I got to get my highlighter out. Now everything in the court of record in yellow, I highlighted everything in yellow that where the claimant is telling me something as a juror. Where is she screaming out to me as a juror? And so that is all highlighted in yellow. So I keep running down. So this is now we're going to get into the actions and what the grand jury brought forth. Now, when the grand jury brought forth their 4 charges or 4 actions, the counts, okay, when they brought this forth, each one had a definition, and it tells you what happened. So, for instance, count 1 is, and I highlighted in blue everything that was a judgment or an action where there needs to be judgment. So in blue, you're going to see all of your charges or actions, and then you're going to see that'll go more with judgment. All right. So they did unlawfully ignore challenge of jurisdiction when it was challenged. There was no rebuttal written correspondence to prove jurisdiction, and confession of judgment. So part of the judgment on this can be that in the verdict that since they didn't respond to anything, there is an automatic confession of judgment of their guilt. And so that can be put into the verdict because they were unlawful and were in default judgment for answering jurisdiction. So that can be brought. So here is count 2. Count 2 is highlighted, theft and unlawful conversion. This one actually works 2 ways as far as the judgment is concerned. So it's highlighted in blue for judgment and charges. So there was 2 different ways that they broke this, that the that the defendants and what I see broke this. The first one is a conversion of personal property occurs when the unauthorized wrongful assumption and exercise of dominion and control over the personal property of another to the exclusion of or inconsistent with the owner's rights, or any conversion not in accordance with the law of the land. Well, on this part of the action or charge is when they took her horses. When they stole her horses and they just ripped her property, that you can't just come in and take someone's horses like that. Like, for instance, I'm just going to let you know, on my property, if I shoot my dog, I shoot my dog. If my dog's sick and I feel like I need to put my dog down, they don't come and arrest me because I put my dog down. If I go outside and eat a chicken and cut one of my chicken's heads off and like decide to cook it for dinner, like nobody's coming out and arresting me for that. They should have never arrested her for her horses. I'm not going to get on my tangent. But what I'm saying is, on this part, they did not. Her rights to have her property and do what she wanted with her horses was her rights. They can't just come and take them. And so there's the theft on that end. But then the second way that there was theft and unlawful conversion is when the unlawful conversion is when they change their identity and it's been trafficked in a foreign jurisdiction of law and applied to foreign people, persons, or things. And so this is where they did not prove jurisdiction and it continued to traffic the straw man out into the courts. All right, so count 3, personage. This will be the same thing. It's just like unlawful conversion as far as your standing where they didn't prove jurisdiction. But count 4, guys, count 4 is amazing. I was so excited when I saw this. So these, again, are all in blue. Number 4, this one. Malicious prosecution with a tort. Let me explain a tort. A tort is when there is damages that need to be added to it. So an action for malicious prosecution is the common law's response to the victim's cry for justice, where a criminal prosecution was instituted contrary to law. Through the action for malicious prosecution, the state is held accountable for the acts of the defendants who do not enjoy absolute immunity for violating the liberty of the person and human dignity arising from the botched prosecution. The action, therefore, is an attempt at restoration in monetary terms of those entrenched constitutional values. In the language of a tort or delict, the claimant for such an action alleges wrongfulness, that the conduct of the defendants was unlawful, and that it failed the test of reasonableness. Okay, so let's just talk right here. So this kind of breaks down the whole charge. So it does say the malicious prosecution, the state is held accountable. Now, if they're not held responsible, the defendants are held responsible, and they're held personally responsible, stripped from all immunity, but the state is held accountable. Well, we just need to hold the state into account, okay? Now, let's just make sure that what we have here for the claimant is that let's just make sure it fails the reasonableness test. Within this charge or action, it tells you how it makes the test. So the reasonable test is, and that it is motivated by improper purpose or malice. So, number 1, was the claimant prosecuted by the defendants? Yes. Number 2, was that prosecution, was it instituted against claimant without any just or reasonable cause? Well, the jury will have to decide that. I say yes, but the jury will have to say, did that happen? And then number 3, that the prosecution was instituted with the malicious intention, that is, not with the mere intention of getting the law into effect, but with the intention which was wrongful in fact. So, number 3, I say yes, but the jury will have to decide if that's the case. And if that's the case, then malicious prosecution did happen, and so now the state is held accountable. All right, everybody got that? That part's in blue. We're going to move forward. Now I'm scrolling through here. Now you start getting into the facts and evidence. This is the statement of facts and the specifics. This part of the court of record, the statement of facts, that is the claimant's entire testimony in writing. That is where you're going to be able to look through here and go, what happened and where is it? This is where you're going to get the story and say, hey man, what about that lease? When they went and leased the horses to come from the rescue, when was that? Now you have two options. You can go to the timeline and go look at the timeline and look where it says lease of the horses, or it's right here. Right here, the leasing of pasture land. It's Exhibit G, pages 229 to 37. So it would be right here. All right, so there's different places where you can find it. But anyway, I'm scrolling through this because we don't need this right now. We don't need the facts and specifics. We're going to the conclusion because we're going to look to see if our claimant is telling us anything. What is she saying? She's not going to tell you anything in the facts and statements. That's going to be just a timeline. But right at the end of it, when you get to the end of all that, be looking because your claimant's probably going to be talking to you when she gets right down to the conclusion. Here you go. We have an issue on this case, okay? It says it right here, right next to the conclusion. The grand jury ordered 4 other cases that are pending in the inferior courts to be tried by a jury of peers that are being continued and scheduled for another hearing regarding the case numbers. There's the case numbers. When the grand jury originally met in November, they ordered our trial pettit jury to try the whole gambit of cases. Well, they couldn't all get put together in one. It was too big to put into one, so they'll have to be broken in 2. That needs to be mentioned in the verdict. It's highlighted yellow. It probably needs to be highlighted a different color, but it's yellow to know that it needs to be put in the verdict. All right, so now we're at the conclusion. The claimant has proven in all these cases there was no corpus delicti. Corpus delicti is injured party. That is to say, these cases have not produced a party that claimant has injured or harmed or stolen from. The only injured party in the cases is the claimant. The evidence is clear that the defendants have exceeded their jurisdiction. That is going to be asked for and have acted with malfeasance and dereliction of duty by not giving a claimant a speedy trial, due process, or deciding jurisdiction when challenging all these cases. Now, that's all blue. Remember, blue is for charges. I have green here because green kind of puts yellow and blue together. So yellow and blue makes green. So some of this is what the claimant is asking for, but some of this also deals with charges and remedy, like restitution. So I just put it all in green. So look, this is what she's asking for. Claimant has proven that defendants repeatedly arrested claimant for the same charges multiple times, that it was a direct violation of her rights. She's telling you, look, this is where my evidence and my proof comes in. Claimant has shown a pattern. So she's telling you there's a pattern, and there's a pattern of how these cases are amplified. She's asking you, she's asking the jury, look, this is what I've shown you guys. Now, jury, do you see what I see? Do you see the pattern? Do you see how they use inflate prosecution by utilizing unlawful means, transforming cases from one court to another, and just adding charges when nothing has happened? Do you see that? So she's telling you, but she's asking you to see that. She's now letting you know defendants are determined to imprison claimant, still have warrants. Police are still out looking for claimant. Claimant's been in hiding since November 5th. So she's telling you, look, guys, I've been in hiding since November 5th. So she's giving you a timeline of how long she hasn't been able to go home. The police are actively harassing and intimidating claimant's minor children. in search for claimants. So now she's telling you, guess what? I have more injured parties here. My children are being injured. And so she's letting you guys know this so that it will help you when you come to make a verdict. She's also telling you that how long has this been going on? It's been 6 years that she's had to wait for her day in court. So she's giving you guys information. She's telling you that the kids had to change school. So this helps with punitive damages or different things. So all of this is important when you're trying to figure your stuff. So now we're on demand for relief and judgment. So this is where, so that was the conclusion of everything. She kind of gave you a conclusion, told you about the charges, asking to tell you how things have been since, and now it's demand for relief and judgment. Claimant wishes. So here we go. We've got to look. Claimant's now wishing for something. She's talking straight to the jury. Claimant wishes for declaratory judgment against defendants for actual damages, punitive damages, the return of claimant's personal horses and donkeys, reasonable attorney's fees, reinstate driver's license, clearing claimant's record, the cost of this action, and any other just or proper relief that the jury of my peers sees fit to grant. Okay, so she's telling you, look, I want all of this stuff returned. She wants her horses returned. And if she can't figure out, if they can't return her horses, you guys may actually want to put in here, not only does she want her horses returned, but she wants to know where they went so that she can go buy them back from whoever they sold them to, and try to work a deal to get them back. So that's something that the jury needs to look at to make sure all of this is mentioned. She's asking here again, she's asking that the court enter a judgment that defendants have acted arbitrarily and without care and have abused their delegated authority and have acted not in accordance with law but under color of law and in excess of their vested constitutional jurisdiction. So when the claimant asks for a declaratory judgment, basically what that means is she's saying, look, this is what I see, and I want you to make that known out loud, that you see the same thing. Will you verbally put this on the record and type it out that this is what happened, word for word? And if you guys agree that what she says is true, she's asking you to make it. There's a few of those declaratory judgments in here. She's asking if you guys will declare it for her. Now, when it comes into injuries, this is all injuries and restitution. The defendant's name, they have to be listed. They have to be listed individually. So you can use some of the same wordage, or you guys could put something else in. But for injuries caused by defendant disregard for the claimant's substantive rights, for exceeding jurisdiction as a duly sworn judge, harassment, intimidation, or you guys can put anything you want in here, for his lack of knowledge of the law, blatant disregard for rights of one of the people of common law jurisdiction, which he has no immunity. Claimant requires from defendant damages in the amount to be determined by a petit jury. So she's telling you why she wants damages, and she's letting you guys figure out what they are. But right here where I went from yellow to green, bam, she slaps in there an adequate proof that he has learned the law regarding jurisdiction and the constitutions of the United States and Arkansas. There you go. It's put in there, and the proof. Well, when we go back, who is held accountable? Who's held accountable? The state is held accountable. How do we hold the state accountable? Well, we're fixing to go look at how we hold the state accountable. Let's look at this. I hope you guys see how to kind of decipher the court of record, how to look through it and find what you're looking for. Let me go to the notes. So, how do we hold the state accountable? So I've been thinking about that. And look, you jurors, you guys need to think about this. For real. Like, everybody needs to put their heads together here, because this is a monumental moment for us, because it's just, I'm just telling you guys, it was absolutely Creator's hand when our grand jury gave this verdict down, and it just so happens that it says holds the state accountable right there in it, because that gives us the shoe-in to be able to really try to affect real change here. Okay, so these were just my brainstorms, guys. Okay, this is just Kimberly brainstorming. You guys are there's 12 of you, 13 if you count our alternate. There's 13 of you guys. Y'all could really brainstorm this out for real. So I said the state is required to teach and train their principals and agents so this doesn't happen again. Those principals and agents need to know about jurisdiction, common law, sovereign and political status. They need to be taught common law. The cops need to be taught the same things. We have a thin red line training packet that we could absolutely have someone come and do a training on. No victim, no crime. It teaches the cops no victim, no crime to stop this mess. And they all need to be taught about property rights and constitutions. Another option is to have our 4 grand jury investigators involved in every step of the process from planning to execution and even to progress made. What I'm saying there is, look, if we're holding the state accountable, which means they have to give an account, then our grand jury investigators, who are untouchable, could absolutely be put in the planning process and part of the planning process, part of the progression that's made in the execution of training these people to realize the constitutions and the law and what's real and what's not. And so that's ways that we can hold them accountable. Now, guys, that is something I just came up with trying to put this thing together. If you guys really think about it, y'all might be able to come up with a whole lot more or even better. So that's what you do on number 6. These are the questions that you ask when you guys are deliberating and trying to find a verdict and getting the verdict out. The next thing is, does claimant ask for anything, which I already showed you guys. We went through the court of record, and I showed you where we highlighted everything that the claimant asked for. If the jury agrees with the claimant's wishes, then what the claimant asked for is added into the verdict. It's added either in the judgment portion of the verdict, or it's added into the restitution section of the verdict, or the accountability section of the verdict, because the state being held accountable, I mean, anywhere you're actually going to put this verdict together, kind of like the court of record, you're going to have headings. So you'll have like the judgment heading. You'll have like the restitution heading. You'll have the cases heading. That's where I'm coming to here in just a second, okay? The next question, and I gave the examples. All those examples right here for did the claimant ask for anything, the examples I just went through in the court of record are mentioned here. I'm actually not going to mention them again because I gave you pages to go look at, but I just walked you through it. The next part, is this case from de facto? Okay, I'm just going to let you guys know, 95% of all of our cases at this moment are going to be from de facto. They're going to be someone who was harmed by de facto, and they're bringing it to our court to get justice. So that's a question you have to ask. If this case is from de facto, then each jury for those types of cases must include all case numbers from the de facto in the verdict and state whether the claimant was found innocent or guilty for the de facto case numbers. This is key because in the way law works and the way our court as a superior court, our court is the general jurisdiction superior court. When we take a case and we rule on a de facto's case, our ruling from our petit jury is final. It cannot be uprooted. It cannot be reviewed. It's final. And so if those court cases are mentioned and the claimant, let's say, and we don't say the claimant was found not guilty. Now, there is no not guilty in common law. There's innocent or guilty. That's your two choices, innocent or guilty. And so you would read off those case numbers and say, I think I give an example. Because you guys have heard these de facto cases and are making your ruling on them, they must be stated in the verdict of the case. And I think I gave an example. Yes, okay, here. here's an example. So in Garland County District and Circuit cases, we find the claimant, then you put the name of the claimant, for case number 26CR-21-231, innocent. For case number 26CR-21123, innocent. And you just have to make certain that each one of the de facto cases is covered here. Cannot leave a case out. That has to be made sure that it's right. And those case numbers will be in the court of record for you to confirm. So, question number 9, the jury needs to ask yourself, are there special instructions? Are there special instructions in the court of record? If so, you have to add it in the verdict. Okay, here's the example. The example is this trial was unable to review all of the cases for the claimant because it was too much, or it was too much for one trial. I'm going to change it to that. Too much for one trial. So a second trial will be scheduled for the jury to hear the cases with case numbers, and then you list the case numbers. List case numbers. It is in there. It's going to be on court of record, page 19. I just went through that, and it's highlighted on page 19 of the court of record. It's where it is listed, and it lists the cases. It tells you that the grand jury has issued an order for all of these cases to be heard. Not all of them have been heard yet, but they will be. And those verdicts will come out as each case is heard. Okay, so that's got to be in there. And then the last question, and let me just tell you guys, I'm just telling you, if you guys come up with more questions, this is just where I'm at so far. We are building this from nothing. So if you guys come up with more to add to this, great. If you come up with a better way, great. This is just what, as I'm looking at it, this is what I see, and this is what I see that the jury needs to pay attention to. But I also want us to, as we're learning how to do this with the court of record, I want to teach the claimants. So many of you that are jury members are yourself going to be a claimant of a case. And so I really want us to learn as a group how this communication with one another works from the claimant to the jury using the court of record, because I think it's a very important tool. Because, for instance, the claimant just can't come talk to the jury and tell the jury, hey, this is all what happened, but this is what I really want, and this is what I'm asking for. Can you help me guys out? Her only way, or their only means to do that, is through the court of record. And so that needs to, we all need to be conscious of that. So number 10, should defendants be remanded? Now this is interesting. Okay. This is where it gets tricky. And I understand, okay, so I know that the common law says and states that it doesn't matter. If our jury says hang them, they have to be hung. If our jury says they go to jail, they go to jail. If our jury says they need to be stripped of title and never work in the government again, it happens. But it has been said by others that Anna really doesn't want us to utilize our jury in that way right this minute. And so do we really want these people to work with and find a way to work? So this is a possibility. And guys, I'm not telling you that this is what you need to put in there. I'm just telling you this is what you can put in there on this one. You do have to put the case numbers and a lot of that stuff I mentioned before, but this one, this number 10, this is where the jury needs to decide. But the jury can always add into their verdict jail time. But Anna's asked us not to go after de facto officials in that way, because she wants us to try to learn to work together with these guys and let them take responsibility for their own people. So what we can do, and it is a possibility, so in the verdict, the jury can wish that the facts and evidence, so basically just how Cheryl is, Cheryl, just how the claimant is using the court of record to communicate to the jury with wishing and asking and seeking. The verdict of the jury can use the verdict to speak to the Supreme Court Justice, the governor, because this will go out to all of them. But the jury can ask. So the jury can wish that the facts and evidence and verdict of this case be brought before the Judicial Review Council and ask them to investigate their officers, but that they and then the jury would give their recommendation. Okay? So here's an example. All right, so an example of all that I just read. The jury wishes the defendants, list them, be investigated by the Judicial Council, and jury recommends all officials are fired from their position and that they can never work as a public servant of government again. And so that's a recommendation. And it's also asking for an investigation. If this is such gross negligence and malicious prosecution that the state is held accountable, even in the thing, and it's been botched, then definitely it needs to be discussed between the jury. If it needs to go before the Jural, should it be asked to go before the Judicial Council? And you're not telling them to do it. You're just asking them to review it. And hey, by the way, we've looked at all this evidence, and this is what we recommend based on what we saw. So that's kind of where it is. Now, as far as how it's written, if you see these questions, the best way I can think of to have this thing written is where you see these questions, that's going to be your like subtitle of your subsection of your verdict. You know, who's the injured party? You would say such and such is the injured party. And so you can bring restitution, judgment. You can utilize these to help you build your subsections of your verdict. Gosh, I hope I made that make sense when I said that. It didn't sound like it came out right. All right, so I am coming back out here. That is all I have on the teaching. So I know I unloaded some things on you guys. Any questions? Does everybody understand kind of how that works? Did I kind of make it clear enough? Any questions on all of that? All right, I'm assuming nobody has any questions. If not, that's all I've got on the teaching. I will go ahead and stop the recording.